The free law movement, at least as it exists since the dawn of the internet, is based first on the idea that the public owns the law and has an undeniable right to know its contents, especially where we are all bound by the presumption of knowledge of the law and live under the admonition that ignorance of the law is no excuse. Most people, including most lawyers, have no idea how complex the process is by which governmental entities, be it the legislature or regulatory agency on either the federal or state level, first create and then communicate official changes to those large bodies of work. It's important to note that there's actually no copyright in anything produced by the federal government. Claims of copyright in primary legal materials and related texts people need in order to interpret or even understand that black letter law raises challenges to what we can publish, whether we can publish a comprehensive set for all 50 states.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speakers, Craig Newton and Sara Frug. Craig Newton is co-director of the Legal Information Institute. A member of the California Bar, Craig previously represented clients ranging from some of the world's best-known companies to pro bono litigants in a wide range of civil disputes with a focus on contracts, licenses, patents, and trade secrets. He is a graduate of Cornell Law School and the U.S. Naval Academy. Sara Frug is co-director of the Legal Information Institute, where she has overseen software engineering initiatives ranging from automated definition extraction for the U.S. Code and CFR to publication of a comprehensive collection of U.S. state regulations to linked data from regulated objects. She has been a panelist at the Legislative Data and Transparency Conference and a fellow at the Harvard Library Innovation Lab. Before joining LII, she was a research associate at Harvard Business School. She is a graduate of Harvard College. The webinar presentation you're about to see will be approximately 1 hour, and Craig and Sara will be joining us live for an audience question after the presentation is complete. If you have any questions that come up during the presentation for Craig and Sara, please feel free to submit them through that Q&A button at the bottom of your screen. Now, without further ado, here are Craig and Sara to discuss how laws get online, challenges in review.
Hello and welcome to this presentation we're calling How Law Gets Online, Challenges in Free Law. There will be two of us speaking today from two different but complementary perspectives. My name is Craig Newton, and I'm co-director of the Legal Information Institute at Cornell Law School and a member of the California Bar since 2007. In just a few minutes, you'll be hearing from my co-director and longtime colleague, Sara Frug. Sara is LII's Chief Technology Officer and is ultimately responsible for the LII website many of you know and use regularly. She's particularly knowledgeable about the various government data sources that provide the material for our largest collections, namely the United States Code, the Code of Federal Regulations, and the regulations of all 50 states. I, on the other hand, am primarily responsible for anything that we create from scratch, so to speak, whether it's the student-authored previews of our Supreme Court cases or the entries in WEX, our legal encyclopedia dictionary, or less substantive stuff like our donor newsletter or our fundraising appeals, though Sara certainly does a lot of that too. While you've probably never heard of either Sara or me before today, it's likely you've used our website at law.cornell.edu, which came about more than 30 years ago at the dawn of the internet era with a mission to demonstrate a strong public demand for legal materials that were then found almost exclusively in books inside law libraries. To satisfy that demand with technology that would free the information from those books in those libraries, and to test the theory that both the bar and the public would come to accept high-quality digital representations of what was in those books. While that may sound like a foregone conclusion to our younger audience members today, those of you who are old enough to remember the world as it was in 1992 may well agree that none of those things were certain when our predecessors began this project by mailing compact discs to subscribers before transitioning to BBS and then listservs, Gopher, and ultimately the World Wide Web, where legend has it that ours was the 41st website and the first one not about either theoretical physics or model trains. The free law movement, at least as it exists since the dawn of the internet, is based first on the idea that the public owns the law and has an undeniable right to know its contents, especially where we are all bound by the presumption of knowledge of the law and live under the admonition that ignorance of the law is no excuse. From the outset, LII has been about demonstrating both an unmet need in the world for reliable legal information and technical solutions to meet that need without cost to the public. Today, the website welcomes tens of millions of visitors each year and features a broad array of both primary legal resources and original content. This presentation today focuses on the primary sources and mostly the U.S. Code, the Code of Federal Regulations, and our newest collection, the regulations of all 50 states. And the reason we're talking about those is because most people, including most lawyers, have no idea how complex the process is by which governmental entities, be it the legislature or regulatory agency on either the federal or state level, first create and then communicate official changes to those large bodies of work. So even if infinite monkeys at infinite typewriters for an infinite amount of time would eventually recreate the entirety of the U.S. Code, for example, that is a dynamic body of statutes which changes regularly. In other words, it's one thing to make a reliable copy of something as large as the U.S. Code or the CFR or the regulations of all 50 states, and it's something else entirely to keep that copy current. And so that's a process largely driven by technology. It's all about proper markup and code structure and many, many other things that were not covered either in law school or the schoolhouse rock, how a bill becomes a law. But we think professionals like you should be aware of, because if you have some rudimentary insights about what's going on behind the scenes while you're perusing a legal research database, you'll be better positioned either to feel confident that what you're looking at online is accurate or to detect that something might be a little off and maybe you should take a closer look. And by the way, this is true not only for free law resources like LII or Justia. Your paid research platform of choice, whether it's Westlaw or LexisNexis or Fastcase or whatever, employs a small army of technologists to make sure that what you're seeing is current, accurate, and comprehensive. In other words, the process of putting legal materials online looks less like this and more like this. So here's what we hope you'll take away from this webinar. First, Sara will explain in detail how a big corpus of law like the U.S. Code or the CFR gets online and how it gets updated to keep current. She'll focus particularly on ways in which that process can break down and yield results that reduce the effectiveness of the end product and its utility to you when you're doing legal research. She will explain how the challenges are different when you move out of just federal materials and down the jurisdictional stack, so to speak, into state or local materials online. Then I'll be back to talk about recent and ongoing litigation and what it has to say about how copyright can and cannot limit the dissemination of primary legal materials and adjacent materials necessary to understand and interpret them. We'll talk about case law governing the government edicts doctrine, incorporation by reference, and whether there's a role for antitrust law to have a say in how legal information is created and distributed by the giants in the legal information industry. So now I'll turn the presentation over to my colleague and co-director, Sara.
Thank you, Craig. My perspective here is that of a legal information publisher, taking free and open primary and secondary data and turning it into legal information systems that support the development of knowledge. Legal information service providers work across large numbers of corpora and knowledge bases, standardizing content, detecting features, extracting metadata, mapping and integrating information, and presenting it all in a way that makes it more understandable. I should say that at LII, much of the applied research focus devoted to what we call statutes and regulations is probably more accurately characterized as enhancing publications of the U.S. Code, CFR, and now state regulations. To give you a sense of what this entails, we can begin by inventorying a basic set of features that LII pioneered as the first online law publisher, and subsequently extended over the course of more than 30 years of publishing legal information for the public. Each of the features noted responds to an information need that users encounter on the web, whether navigating to a legal text from a table of contents, browsing from a list of topics, or far more commonly arriving at a particular section of a legal text via an external search engine with very little context as to what's there. Page headings and indentation clarify the structure of a section. Hierarchical navigation situates the page at hand within its containing corpus. Lateral navigation facilitates traversal from section to section, and citation and reference markup supports rapid resolution of cross-references within sections, a corpus, or between corpora. Entity resolution, for example of named acts, and definitions clarify the context of the language being used, signaling a reader, for instance, when a term in one section has already been defined elsewhere. Other features require extraction and amalgamation of metadata from multiple corpora, such as cross-corpus citations, and other external resources, including indexing vocabularies, directories, specialized knowledge bases like Agris and Agravoc for agricultural information, or the private letter rulings of the IRS providing guidance for the tax code. Yet other features rely on the combination of the kind of original explanatory content that Craig mentioned earlier and machine-driven annotation to clarify text that seems to fly in the face of common sense. More about that in a moment. How do we get there? We are making steady progress toward a data environment that maximizes comprehensiveness, timeliness, standardization, cross-referencing, taxonomies, and explanations. Here, it's helpful to quote from Principal Analyst and Director of the Systems Analysis and Quality Assurance Team for the Office of the Clerk in the U.S. House of Representatives, who frequently notes the following aspirations for government data. In her words, government data should be accessible, accurate, complete, described, free, machine-readable, permanent, searchable, timely, and usable. It's a tall order, but combined with the work of the Government Publishing Office to earn and maintain ISO 16363 Trustworthy Digital Repository certification for govinfo.gov, it means that the federal government at least has the infrastructure to host a comprehensive, authoritative collection, at least of federal law. But in order to understand where we are now, it's worthwhile to revisit where this all comes from. Legal information services, source data included, still bear some relationship to print. Whether deeply print enmeshed, as with the annual online publications of the CFR finding aids in the packet, or heavily data-centric, as with ecfr.gov, the print mindset persists. And we are still adapting from original print publishing processes and conventions. Not all content is included in publication. Not all included content is represented in machine-readable format. Not all machine-readable formats are fully featured when they're published. When you look back to the mindset of print, a lot of this makes a bit more sense. In print, space is expensive, so formatting might be altered in the interest of being more economical, and incorporation by reference is all the more tempting. More about that later. In print, updates take a long time to be incorporated into the main text, so readers are already accustomed to looking in many different places for a single piece of information. In print, it takes a long time to find things. Marginal notes might be useful, or one might assume that a separate book is open on the reader's desk next to the book containing the primary law text. A favorite example, and one which should be a trivially easy question to answer using the general and permanent laws of the United States. How many stars are there on the United States flag? For USC Section 1, entitled Flag, Stripes and Stars on, sounds promising, but it says there are 48. The rule is stated in the following section, titled with the less search engine optimization friendly saying additional stars. And the 1959 executive order, referring to the rule in Section 2, is in the notes to Section 1. So it's there, minus the instant gratification we've come to expect from modern information services. More challenging is the content that's not included in the publication at all. Craig will go into this in more detail, but briefly, the practice of incorporation by reference, which is explained in the Office of the Federal Register's Incorporation by Reference Handbook in the packet, makes content, whether belonging elsewhere in the same corpus, elsewhere in another government corpus, or elsewhere in an entirely independent corpus, part of a regulation by referring to it rather than by making a copy. The benefit, particularly in the era of print, is that only one copy of the content is maintained by the entity responsible for maintaining it. The disadvantage, particularly important for applied researchers who are trying to analyze entire corpora, arises when the content incorporated by reference is not reusable or available or accessible. 145 Swiss francs might not sound like all that much, but stay tuned. An even more difficult scenario arises when the content of a corpus is made inaccurate because external events have affected the applicability of the content without altering the content directly. This can happen when the Supreme Court finds a statutory provision to be unconstitutional, a court enjoins enforcement of a law, or an agency temporarily suspends enforcement of a regulation. A great deal of data from a plethora of sources must be gathered, synthesized, and mapped to the underlying text in order for legal information services to tip off their users that what they're reading might not be in effect. More quotidian challenges include gaps caused by intermittent interposition of images into textual corpora, including images of text. The Office of the Federal Register's document drafting handbook in the packet makes provisions for figures, forms, tables, notes, and appendices, all of which can diverge from data standards otherwise in use. This slide shows a presentation of a data table in the very richly featured Electronic Code of Federal Regulations website, Not only is the text trapped as a series of pictures, it has a different orientation in the headings than in the rows to conserve space on the page. There is, of course, no horizontal scroll in print. So legal information publishers like LII have our work cut out for us. We remediate issues in the source data that threaten web accessibility for readers with disabilities. We improve usability by filling in missing pieces to provide a standardized user experience across many corpora. We build crosswalks to break down silos between corpora across branches of government and down the jurisdictional ladder from federal to state materials. We even do what we can to incorporate external information to make sure that what the text of the law means reflects the state of the law as it stands right now. But I still haven't explained how we get from lawmaking and rulemaking to legal information services. And reminder that we are primarily focused on enhancing the U.S. Code and CFR. Now, I won't trouble you with Schoolhouse Rock or the details of legislative process. How our laws are made by the parliamentarian of the U.S. House of Representatives is the gold standard regarding any details, and you can see that in the packet. What I will note is the emphasis on the foundations of the government's obligations to disseminate the law, and a couple of caveats. Here I'll quote. One of the important steps in the enactment of a valid law is the requirement that it shall be made known to the people who are to be bound by it. There would be no justice if the state were to hold its people responsible for their conduct before it made known to them the unlawfulness of such behavior. In practice, our laws are published immediately upon their enactment so that the public will be aware of them. And every public and private law passed by Congress is published in the United States statutes at large, prepared and published by the Office of the Federal Register, National Archives and Records Administration, and made available via the Government Publishing Office's website, govinfo.gov. When a law is enacted, the House Office of the Law Revision Council classifies its provisions to their respective destinations in the U.S. Code, and subsequently they incorporate updates into the text of the U.S. Code. Now, the legislative drafters, the House Office of Legislative Counsel, explain several caveats, and I quote, "It is helpful to keep in mind several other points when using the U.S. Code. First, the code has a different structure than the slip laws and is not a verbatim replication of them. Section numbers and cross-references will usually differ. There could even be some differences in language, although no substantive changes are intended. Second, the process of classifying a slip law to the code often involves splitting it up and placing different provisions of it in different parts of the code. Finally, unlike the slip laws and statutes at large, the code is updated to reflect amendment by later statute. I'll use the example of the National Technology Transfer and Advancement Act of 1995 included in the packet. You'll notice two different types of amending language here. In Section 7, the amendment to the Bayh-Dole Act is made as an amendment to 35 U.S.C. Section 210E. By contrast, in Section 8, the amendments to the National Institute of Standards and Technology Act are made as amendments to the Act. The difference is meaningful. Title 35 has been enacted as positive law, so the text of the U.S. Code is legal evidence of the law. Title 15, by contrast, has not been enacted as positive law, so changes must be made to the statute, and the compilation into the U.S. Code serves only as prima facie evidence of the law. For reference, on its website, the Office of the Law Revision Council notes positive law titles with an asterisk. But this creates a misalignment. The National Institute of Standards and Technology Act originated as a statute over 100 years ago. In the table of popular names of legislation, there is a listing for the former name of the Act, Bureau of Standards Act, and then it refers, see National Institute of Standards and Technology Act. Because it has not been enacted into positive law, there is not exactly an official publication of the current version of the Act. Imagine collaborating with colleagues on a brief you've drafted, and what you're asked to review is not a red line, but just a series of documents containing successive sets of instructions for where and what changes to make. Of course, it's not quite as bad as all that. The House Office of Legislative Counsel maintains statute compilations. This is an excerpt from the NIST Act as amended through Public Law 117-286, included in the packet. These are not official, but for statutes that have not been enacted as positive law, they are the closest thing we have to a standardized version of acts of Congress published by the government. Close enough? Most legal information publishers and consumers we've spoken to over the years don't seem too concerned. But the mechanics. These are a bit closer to the typewriters than you might think. Above is a print rendition of 15 U.S.C. Section 278. We used to work with typesetting codes. In fact, the Office of the Law Revision Council is still offering bulk downloads of the typesetting code in the format LAI first used to transform the entirety of the U.S. Code for web publication more than 20 years ago. Mercifully, the U.S. Code publication process has long since migrated to focusing on extensible markup language, or XML. Instead of instructions for how to format the next block of text, XML provides containers, XML elements, and opportunities for non-textual annotations, XML attributes, to represent whatever information the publisher considers to be important. Furthermore, the U.S. House of Representatives uses the United States Legislative Markup, USLM standard, which provides semantically meaningful elements such as section and subsection, and attributes such as identifier, designed specifically to represent legislative information. As mentioned in the USLM user guide in the packet, following a 1999 feasibility study on XML/HTML, the Committee on House Administration adopted XML as a data standard for the exchange of legislative documents. As a result, the U.S. House of Representatives first publicly released congressional bill data in XML in 2004. Since that time, a number of best practices and consistent approaches have evolved around the use of XML across various industries. To the greatest extent possible, the design of USLM leverages current best practices in legislative information modeling, end quote. USLM is compatible with the International Legal DocML, a Komentoso XML standard, which makes it straightforward to produce interoperable outputs. This same format is used to publish bills and statutes at large compilations on govinfo.gov. So using the clean USLM markup and monitoring the Office of the Law Revision Council's website for currency pages, classification tables, and the table of popular names of legislation, we can use metadata and direct textual comparison to determine what has changed and automate the process of retrieving and producing a timely enhanced U.S. Code publication as we publish it on the LA website. Other features require data integration or the application of human language or artificial intelligence technologies to realize. We derive the authorities information by parsing a minimally machine-readable version of the parallel table of authorities. For the annotation and resolution of defined terms, we use a combination of computational techniques informed by feedback from our audience to produce the functionality. Now, the authorities information brings us to executive agencies and the rulemaking process, in our world focusing on how CFR is made. The guide to the rulemaking process in the packet provides an overview, but briefly, from the point of view of a publisher, data about rules is available from 5 major sources, as well as individual agencies. The Office of Information and Regulatory Affairs, OIRA's website, reginfo.gov, publishes the Unified Agenda and Regulatory Plan. The Federal Register publishes notices, proposed rules, and final rules. The regulations.gov website publishes rulemaking dockets and comments for participating agencies. eCFR.gov publishes the enhanced, up-to-date, point-in-time electronic CFR publication, and govinfo.gov from GPO publishes the bulk eCFR data and the CFR as published in print. While building our CFR features, we also make use of finding aids from the legislative and executive branches, indexing vocabularies, standalone directories, and external knowledge bases. But here I'll focus primarily on the wide variety of data formats we encounter with rulemakings. Tracking the rulemaking process starts out with a unified agenda. This is searchable and downloadable in a machine-readable format. To take an example from fall of 2020, you can see an XML sample here. Note that it is not in the USLM format seen on the US Code. There are elements for agency and parent agency. This will be relevant shortly. The pre-rule stage takes us to the Federal Register website. For a rulemaking that follows the notice and comment process, the regulations.gov website maintains the rulemaking dockets and comments. It has its own data dictionary and typically enables downloads of PDFs of comments from the dockets, but not XML. There is a regulations.gov API with metadata fields suitable for cross-referencing made available in JSON format, although the relationship between rules, rulemakings, and dockets is not always entirely intuitive. After the comment period, agencies synthesize comments for publication with final rule. And for the final rule, it's back to federalregister.gov. For changes to existing rules, the format is once again lists of changes. The process and data sources that accompany it are in many ways very similar to what we're accustomed to with the U.S. Code. From the Federal Register website and API, XML is available for the final rules, including summaries, indexing metadata, and the rule preamble containing the agency's synthesis of the submitted documents. Here we have an example of the XML for the final rule with a different XML schema and a couple of different ways to represent the agency. And here's the format of the section text itself. For the compiled text of the ECFR incorporating the final rule, ecfr.gov provides an enhanced up-to-date point-in-time electronic CFR publication, which, unlike the annual print edition on GovInfo, is unofficial, but which is up-to-date and widely regarded as reliable. However, a careful observer will note that the ecfr.gov XML is in yet another format. The ECFR XML user guide in the packet provides background about the approach to converting ECFR from typesetting code to XML, as LII once did with the US Code and later on prototyped for the CFR. Although GovInfo has an experimental USLM version, that conversion remains a work in progress and is not yet offered comprehensively. So in order to publish a version of the CFR that is consistent and interoperable with our version of the US Code, LII and other legal information providers have a fairly steep uphill climb to locate, extract, standardize, enhance, and finally publish primary legal information in a way that takes full advantage of as much of the knowledge buried inside as possible. And that's just codifications of federal statutes and regulations. Finally, moving down to the state level, we are presented with far more than 50 times the complexity that we had at the federal level. Although we now have the good fortune to have a standardized feed of state regulations XML, the source data is published by each state as it chooses, whether on its own or under agreement with a commercial publisher, which may publish with contractual or technical barriers to use. And this also applies across branches of state government and, of course, further down to the local level. Looking ahead to Craig's discussion, we have the final and perhaps most extreme example of incorporation by reference in the corpora we're currently working with. If you want to read the California Code of Regulations, you can use the free version offered by Thomson Reuters. However, if you want Title 24, the California Building Standards Code, you're directed to a landing page of the Building Standards Commission, which in turn provides an ordering form to buy or pay to subscribe to the code. 145 Swiss francs was only the beginning. So what you see in legal information systems from government, nonprofits, and commercial services integrates a great deal of non-standardized information from a lot of different sources, and at the moment cannot be entirely complete. As I said earlier, we have our work cut out for us providing information services that rely on free and open access to free and open legal data. And with regard to free and open, I'll now turn the presentation back over to my co-director, Craig. Thank you.
Thanks, Sarah. I'm going to switch gears now and talk about copyright as it relates to primary legal materials and related texts that are certainly helpful and perhaps necessary to interpreting them. First, it's important to note that there's actually no copyright in anything produced by the federal government. And for the longest time, LII mostly published just federal materials as well as our own original content, which meant copyright concerns weren't a big part of our work. But as you know, federal law only rarely covers the entire field when it comes to what we call the law of where I'm standing right now. In recent years, we've become more interested in and more capable of moving down the jurisdictional stack, at least as far as into the states, where copyright becomes an issue in ways I'm going to explain today. Claims of copyright in primary legal materials and related texts people need in order to interpret or even understand that black letter law raises challenges to what we can publish, whether we can publish a comprehensive set for all 50 states, and the extent to which we can design and implement technology to aid our work. In other words, what's ultimately available to you as the end user of legal materials online. Your written materials today include key orders in these 5 cases. I'll start with Georgia v. publicresource.org. This is a 2020 U.S. Supreme Court case. If you don't know PRO, it's the work of a man named Carl Malamud. After he won the Court of Appeal, he joined Georgia's cert petition to have the Supreme Court hear the case because he said he was in search of one rule that applied everywhere in the U.S. instead of just a victory in the 11th Circuit. In this case, the legal materials in question were the Official Code of Georgia Annotated, or the OCGA. Georgia's Code Commission is an appointed body comprised largely of members of the Georgia legislature that is responsible for promulgating the OCGA. The commission hires a commercial vendor, in this case LexisNexis, to create the annotations following a very strict and detailed set of instructions about what to include and what not to include. Then the legislature votes to merge the annotations into the code and then to adopt the merged annotated code as the official code of Georgia. There is no official unannotated code in Georgia like there is in most, though it turns out not all, of the other states. Georgia retained the copyright, but allowed the vendor to monetize the OCGA by selling copies and by allowing it to be the exclusive online publisher of the OCGA. In exchange for the right to monetize the OCGA, the vendor did not charge Georgia to create the annotations. Georgia did make available online for free an unofficial, unannotated copy of the Georgia Code. So what was in dispute was the applicability of something called the Government Edicts Doctrine, which has its roots in 3 cases from the 19th century. In the 1834 Wheaton case, the court held that, quote, no reporter has or can have any copyright in the written opinions delivered by this court, and that the judges thereof cannot confer any such right, end quote. Banks from 1888 is probably the most important to the Georgia v. PRO case. It applied that Wheaton rule to state courts, holding only that quote-unquote authors could hold copyrights, and that neither a judge nor a reporter of decisions could be the author of a judicial opinion for the purposes of the copyright statute. Callahan decided just a few months after Banks sort of went the other way by holding that the official reporter of decisions for the state of Illinois did in fact have copyright in the portions of the volume of the decisions that were, quote, the result of his intellectual labor, unquote, such as headnotes and other annotations. The question before the Supreme Court in the PRO case then was how the Government Edicts Doctrine applied to legislative materials, especially annotations and other materials that arguably do not carry the force of law, but are instead only supplemental or explanatory in nature, especially where those materials were not created by the government itself, but rather by a third party at the behest of the government. The trial court initially agreed with Georgia that the annotations were subject to copyright because they did not carry the force of law. PRO appealed to the 11th Circuit. The Court of Appeal reversed the trial court and articulated a 3-part test. That opinion is included in the written materials. These are quotes from that 11th Circuit opinion. In all of these slides, please pay particular attention to the text that's not in black. There was no dispute that the actual laws themselves are not subject to copyright. Once again, the court's task was to apply the Government Edicts Doctrine from the 19th century to this situation, namely the commercial annotations for hire that were later merged with the actual laws and adopted as the official code for the state of Georgia. Banks was the case where the U.S. Supreme Court said that state judicial opinions, like federal judicial opinions, could not be subject to copyright. The 11th Circuit said Banks was not especially clear on the reasoning for that rule, but it understood the rule to derive from first principles of democracy, namely the sovereignty of the people. They said, quote, you see at the bottom of the slide, quote, when the legislative or judicial cords are plucked, it is in fact the people's voice that is heard. The appellate court went on to say the general rule that legislative codifications are uncopyrightable derives from understanding of the nature of law and the basic idea that the people, as the reservoir of all sovereignty, are the source of our law. And down there in the corner of that slide is a screen cap of an old video we made around 2012, in which LII co-founder Peter Martin is saying this very thing and explaining why we and others like us do what we do. The Court of Appeal continued, because their ultimate inquiry is whether a work is authored by the people, meaning whether it represents an articulation of the sovereign will, our analysis is guided by consideration of those characteristics that are the hallmark of the law. In particular, we rely on the identity of the public officials who created the work, the authoritativeness of the work, and the process by which the work was created. You'll see in a moment why I color-coded those 3 bullet points, but that was the appellate court's 3-part test to determine what materials are copyrightable versus which belong to the people as the reservoir of all sovereignty. And here's its own summary of what it ultimately decided after a thorough analysis of its rule. The purple's the identity, the green's the authoritativeness, and the pink is the process, all of which led to the conclusion that the OCGA was not copyrightable. As I said, this went to the Supreme Court at the request of both parties, and it said, "We affirm the Court of Appeal, but for a different reason." The opinion by Chief Justice Roberts is in your written materials. As you can see from the visual representation of the vote provided by ora.org, the case was not decided along ideological lines. Instead, it appears age may have been a factor. The 5 justices in the majority were the 5 youngest, all under 60 at the time. The 4 dissenting judges were all over 60 years old at the time, and I believe that's significant for reasons I'll explain in just a bit. The court said, in effect, this is straightforward based on the identity of the author. Judges and now legislators cannot be authors for the purpose of the copyright statute when they are working as judges or legislators. So going back to my obnoxious color coding for a second, here's a comparison of the rule articulated by the Court of Appeal and then differently by the Supreme Court. But I think when viewed side by side like this, it's easy to argue that there's not much difference between the two. The court said, and forgive me for reading again, because judges are vested with the authority to make and interpret law, they cannot be the author of the works they prepare in the discharge of their judicial duties. The animating principle behind this rule is that no one can own the law. Every citizen is presumed to know the law, and it needs no argument to show that all should have free access to its contents. Now, in the corner of this slide is a screen cap of that same 2012 video in which LII's other co-founder, Tom Bruce, is saying pretty much the same thing. So I think it's not the rule that differs from the 11th Circuit's opinion so much as the reasoning behind it. The Court of Appeal relied on sovereignty of the people with a capital P, so to speak, while the Supreme Court relied on the premise that we are all presumed to know and understand the law, more of a due process reasoning, if you will. Now, several slides ago, I told you that the trial court sided with Georgia that the only thing a state government can't copyright is a thing that carries the actual force of law, and Justice Ginsburg dissented on that ground. The court's majority said if force of law mattered, states would own the non-binding legislative materials produced by legislative bodies acting in a legislative capacity and could charge the public for access to them. If everything short of statutes and opinions were copyrightable, then states would be free to offer a whole range of premium legal works for those who can afford the extra benefit. A state could monetize its entire suite of legislative history. With today's digital tools, states might even launch a subscription or pay-per-law service. Now, I just skipped some stuff in the middle of that opinion, so I'm going to expand out on those ellipses now. Now, as you read this expert, which I'm not going to read out loud, I'll explain that one of the many conditions that Georgia imposed on its vendor was that the vendor had to make a physical copy of the OCGA available in several libraries across the states. I think it was around 60 libraries. Georgia, of course, pointed to that as adequate public access such that anyone who really needed to read the law in Georgia could go to a library if the unofficial, unannotated version it put online wasn't good enough for their purposes. The Court of Appeal dealt with that argument in a footnote, saying that 60 libraries for 10.5 million citizens of Georgia was insufficient public access. The public domain is the public domain, and you can't restrict that, the court said. The Supreme Court ignored the library copies altogether. There's literally no mention of them anywhere in the majority opinion. Bad news for the librarians out there, perhaps, but wonderful for those of us who put laws online for free. The Chief Justice of the United States addresses only online access, presuming that, quote, a Georgia citizen interested in learning his legal rights and duties, end quote, will go online to find out what those are. And here's why I said before that I think the ages of the justices influenced their reasoning in this case. The 5 youngest agreed, first, that ordinary citizens will go online to learn their legal rights and duties, and second, right there on the internet, they're entitled to find that information, not the economy class version, but the first class version, in the words of the Chief Justice, for free. At the beginning of this webinar, I showed you this slide with the top of the LII homepage on it, and I said a few words about how in 1992, it wasn't a foregone conclusion that the world would ever see online legal materials as authoritative. And 3 decades later, there's the Chief Justice of the United States just sort of assuming that the public will go online to learn about their legal rights and responsibilities. That must have been a very satisfying moment for our predecessors in the free law movement, who heard many, many times throughout those early years that the law was far too serious for something as frivolous as the internet. And now I know our agenda for today says we're going to talk about ramifications at the end of the presentation, and we will, but I'm going to cheat a little bit and give you a real world illustration right now of what the Chief Justice was talking about in that last quote, where he mentioned some important laws a person wouldn't know were no longer valid if they didn't have free access to the Georgia Code annotated, because old laws aren't always taken off the books. Turns out that non-persons like ChatGPT have that problem too. This is a slide I borrowed from a presentation I saw Justia CEO Tim Stanley give in June. He asked ChatGPT this question about same-sex marriage in Mississippi. As you can see, it told him that same-sex marriage was still illegal there. And why did it tell him that? Because the version of the Mississippi Code that the state makes available online still shows that law in the books. So, like Sarah's example about the stars on the American flag, this shows why materials have to be really complete and maybe just not in one collection, but across collections before you or ChatGPT can find the right answer. And lack of completeness can be a problem that can either be policy based, like refusing to go back and formally repeal antiquated laws, or it can be technical, as Sarah made clear. And of course, those technical problems can exist at any point in the process, from the legislature or government agency that is the original author of the work product, down to the state employees or hired vendors who create and mark up the digital version of that work product, all the way down to an online publisher, whether it's us or someone else, whose software fails to detect a change and implement it because of something so small as the wrong kind of dash having been used in the computer code somewhere along the way. The last thing we need to pause on from this case is what the court said about copyright and fair use. It noted that copyright is presumptive and adheres automatically, and if every time someone wants to share the law, they have to first violate a copyright and then defend their actions as fair use, that is, in the words of the court at the bottom of the slide, notoriously fact-sensitive. In the end, the court said, we're going to make a rule that says because the public is presumed to know and understand the law, state legislatures cannot be authors under the copyright statute of materials that are key to that knowledge and understanding, such as the Georgia Code annotated. This isn't about fair use, because fair use, especially in a case about our ability to communicate about the law, is messy, inefficient, and a last resort. But what about when the law contains text authored by a private entity? These three very similar cases in the red box are among those at the forefront now of copyright in the law, and they don't speak to the same scenario as presented in Georgia v. PRO, but instead deal with incorporation by reference, which courts in D.C., New York, and California so far have all agreed falls outside of the government edicts doctrine, but have found Georgia v. PRO to provide important guiding principles, which is why we just spent a lot of time on it. In each of these three cases, there are private organizations that have created industry standards or model codes and copyrighted them, and then governments up to and including the federal government have adopted them into law through incorporation by reference. As Sarah mentioned, Congress has explicitly encouraged this practice at the federal level, and she showed you an example or two of that in action. My example, and I didn't choose this example, the DC Court of Appeal did, is 46 CFR section 39.2009, which you see on the slide says you can power your barge's liquid overfill protection system by hooking up to an off-barge facility so long as your explosion-proof plug conforms to Article 406.9 of something called NFPA 70, which is a copyright-protected standard owned by the National Fire Protection Association, or NFPA. But you'll note that the regulation doesn't actually say what expressly Article 406.9 of NFPA 70 mandates. You have to go to the NFPA for that, and they want your money so that they can continue to gather experts who debate the merits of the various possible features of explosion-proof plugs for liquid overfill protection systems. And that's not an inherently bad thing, right? We want to create incentives for experts to do this work and keep us all from buying shoddy explosive-proof plugs for the various liquid overfill protection systems we use in our myriad barges. And that's well aligned with the purpose of intellectual property law generally. The defendants in these incorporation by reference cases, the folks publishing these standards that have been incorporated into the black letter law by reference, are once again Carl Malamud's nonprofit, publicresource.org on the left, but also a for-profit creator of compliance software called Upcodes that's part of their website on the right. In all these cases, the defendants were accused of reproducing entire model codes or whole chapters of model codes or other quanta of the codes that sometimes went beyond what could be shown to have been clearly incorporated by reference by one or more jurisdictions. The various courts that have handled these cases have usually seen fit to organize the model codes by those that have been clearly incorporated by reference into black letter law and those that have not. All of these cases have the sort of classic cascading dog bite defense along the lines of, I don't have a dog. If I do have a dog, it didn't bite you. If it was my dog that bit you, then you provoked it. In this context, it goes something like, first, Georgia v. PRO and the government edicts doctrine applies. If not, then the plaintiff's materials are now in the public domain. And if not, then the copyright defense of fair use applies. The first of these three incorporation by reference cases is ASTM v. PRO and is 10 years old now. As you can see from the bullets, the trial court originally sided with ASTM in an early motion for summary judgment. In 2018, the Court of Appeal reversed and remanded, instructing the trial court to start over and conduct a full fair use analysis on a completely developed factual record. In that order, it punted on passing judgment on PRO's argument that these standards had passed into the public domain. After characterizing that claim as voicing, quote, a serious constitutional concern with permitting private ownership of standards essential to understanding legal obligations, end quote, it explained it would, quote, leave for another day the question of whether the Constitution permits copyright to persist in works incorporated by reference into the law, end quote. It explained that while it's easy to say the law cannot be copyrighted, it's far more difficult to determine whether an incorporated standard has actually become the law, and that's because the way governments incorporate these standards by reference occurs on something of a sliding scale. There are what these courts seem to think are fairly easy cases where a jurisdiction cites a standard by chapter or section number and says, this is the law of our jurisdiction. And these model codes often include everything a jurisdiction needs to do that, including civil or even criminal penalties for violating them. But there are also circumstances like the explosive plug example I gave you before, where the government says you have an obligation, look at this private standard for the scope of that obligation. And courts and litigants involved in these cases have tried to draw a distinction then between when text incorporated by reference creates a legal obligation versus when it merely defines the exact contours of an obligation that the state has imposed. As you can imagine, that is not a great topic for summary adjudication. Moving to the third bullet of this slide, after the Court of Appeal remanded the case for a full consideration of fair use upon the close of discovery, the trial court on March 31st, 2022, published a 47-page order denying ASTM's motion for summary judgment, and also a 187-page index or appendix in which it went through a full fair use analysis for each and every ASTM standard alleged PRO had published in violation of ASTM's copyright. That order and appendix are in the written materials. Now, just 3 years and 3 slides ago, the Supreme Court said, hey, it would be great if we could avoid questions of copyright fair use when it comes to folks who want to talk about the law. But here we are. Of course, one wonders if the Court of Appeal would have deferred the public domain question and leaned on fair use in its 2018 order if it had been in possession of a crystal ball that would have shown at the Supreme Court's pronouncement 2 years later that fair use was not the way to go. But the timing is such that it created this funny loop where the ASTM trial court is responding to an order from the Court of Appeal requiring it to do this elaborate fair use analysis where there's intervening dicta for the Supreme Court, which cast doubt on the viability of fair use to do the heavy lifting in these cases. In any event, ASTM's appeal of that MSJ denial from March of 2022 is fully briefed and argued at the 11th Circuit, and we'll see what happens next. The next case, ICC v. Upcodes, is actually 3 cases, 2 alleging copyright infringement and 1 alleging false advertising, which have now been consolidated and are in the discovery phase in the Southern District of New York. You have in your materials a May 27, 2020 order denying the parties' motion for summary judgment in their original copyright case, which dates back to 2017. And the order is quite remarkable in that it goes where the D.C. Court of Appeal was unwilling, holding that anything plaintiffs created that has subsequently become black-letter law through incorporation by reference is now in the public domain. It doesn't dispose of the case, however, because The plaintiffs alleged that the Upcode's website contains copyrighted materials that were never incorporated by reference in the black letter law anywhere. So, in addition to the public domain analysis, there's also a lengthy fair use analysis. The court finds that even if ICC's copyrighted materials that were incorporated by reference in the black letter law are not in the public domain, Upcode's use of them is fair use. As for additional materials belonging to ICC that Upcodes has allegedly placed on its website but aren't part of the black letter law anywhere, the court holds that it cannot rule on the record before it whether or not those extra materials amount to, in essence, a sort of legislative history that is sufficiently related to understanding the incorporated codes that its reproduction by defendant is fair use. These are materials like red lines showing which text a particular jurisdiction chose not to adopt, for example, where seeing that might help a reader better interpret or understanding vagaries in the language as adopted. Now, the third case from which we've included in order is NFPA v. Upcodes, and it's a little different because it comes at the preliminary injunction phase, and therefore the standards and burdens are different, and the court's goal, so to speak, is also a little different, right? In a relatively short order, then, the court was able to rule that fair use creates sufficient questions of fact on whether or not the plaintiff will prevail, such that it could both A, deny the motion for PI, and also B, punt on the other questions raised about the public domain, due process, etc. So let's take some time to talk about fair use in a little more detail. Traditionally, and in its simplest form, fair use pretty much comes down to money. Is the infringer making money, and is the copyright holder losing money? Of course, it's a little more complicated than that, but perhaps only just a little. So maybe some of you noticed that I made a point of noting the PRO is a nonprofit entity, while the other defendant in these incorporation by reference cases, Upcodes, is a for-profit company. One thing to keep an eye on is if and how that influences the fair use analysis these courts and probably their appellate courts will ultimately do. But really, these incorporation by reference cases will probably hinge on the doctrine of transformative use. First, you'll notice this phrase does not appear anywhere in the actual statute on the right side of the slide. In short, the more transformative the use, the less the distinction between commercial and not-for-profit is going to matter, and the more likely a fair use defense will prevail, almost regardless of how the whole four-prong analysis otherwise goes. In other words, even though transformative use analysis typically nests under the first factor of purpose and character of the use, as you see on the slide, it seems to have a way of informing the entire analysis. I can't think of a single case I've seen where a court found a use to be transformative, but in light of the other factors, still refused to find fair use. Transformative use is a concept that the Supreme Court introduced to the world for the very first time in 1994's Campbell v. Acuff Rose Music, the Campbell being Luther Campbell of the infamous rap group Two Live Crew, infamous at least in my house growing up anyway, and the transformative use in question being a parody of Roy Orbison's song, Oh Pretty Woman. In the 2015 case, Authors Guild v. Google, the Second Circuit ruled that Google did not violate copyrights when it scanned whole books, so that users of its Google Books and Google Library Project search engines could find words or phrases in those books that were interesting to them. The Google search results would even include small snippets of the copyrighted works that were relevant to the user search inquiry. The Second Circuit said, quote, "We have no difficulty concluding that Google's making of a digital copy of plaintiff's books for the purpose of enabling a search for identification of books containing a term of interest to the searcher involves a highly transformative purpose in the sense intended by Campbell," end quote. So that's a case where even though many of the copyrighted works were highly creative, the second factor, and Google copied the entirety of the work, the third factor, the purpose of the copying was so transformative as to predominate over the entire fair use analysis. The Supreme Court didn't take that one up, denying cert in 2016 and therefore leaving undisturbed the Second Circuit's ruling in favor of Google. The court did tackle fair use, coincidentally with Google once again as a defendant 5 years later. The Supreme Court ruled that Google's copying of the Java APIs, which were copyrighted by Oracle, was fair use. The court said, first, Google's use of the Java's API was transformative because the copying allowed programmers to work in a different computing environment, but with a familiar programming language. Second, the copied lines were, quote, inherently bound together with uncopyrightable ideas, end quote, suggesting it was unlikely to undermine the general copyright protection that Congress provided for computer programs. Third, Google copied only 0.4% of the entire API. And last, the record showed, according to the court, that Google's new smartphone platform was not a market substitution for Oracle's Java-based product, Java SE. The dissent noted the large financial stakes implicit in this copying, the question of market substitution notwithstanding, but the majority was unfazed by that. Now, we'll come back to transformative use in just a minute when we discuss ramifications for the future. But before that, I want to talk very briefly, about Thomson Reuters v. Ross Intelligence. TR is the parent company of Westlaw. Way back in 2017, they noticed unusual usage patterns by a licensee called Legalese, who is basically a litigation support company. TR sued that licensee for violating the terms of that contract and quickly realized that the company was doing what it was doing because it was handing over tons of case law to its own client, Ross, a Canadian company that has visions of revolutionizing legal research using AI. On the slide is part of Ross's website there. TR settled that first lawsuit with Legalese and then sued Ross, alleging, among other things, that Ross's use of Westlaw's case law violated West's copyright in its key number system and its head notes, etc. In due course, Ross answered in counterclaim. Those counterclaims included allegations that TR's refusal to license just Westlaw's case collection without access to the Westlaw software platform itself and what Ross calls Westlaw's quote-unquote search technology violates Sections 1 and 2 of the Sherman Antitrust Act. West moved to dismiss those counterclaims, but the court denied that motion, and you have that order in your written materials. Here's a summary of some language from the court's denial of TR's motion to dismiss in April of 2022. The citation at the top of the slide is to that order, and the citations in the bullets are contained in the court's order, lest anyone accuse me of doing the slightest bit of my own analysis on the merits here, because I am not now, nor have I ever been, an antitrust lawyer. Basically, Ross's relevant allegations, the court identified, are that TR doesn't separately license its case law from its search tools, but that because of its dominant market position, TR needs to do that for antitrust purposes because, Ross alleges, the market for just the case law that TR owns is distinct from the market for the whole Westlaw enchilada. Ross has also alleged that TR's take it or leave it Westlaw user contracts don't allow those licensees to only use what they want, and then TR takes advantage of the existence of their copyrighted head notes and the key number system, etc., to sue anybody that tries to republish or otherwise creatively use just the case law. Now, in his April 22 order denying TR's motion to dismiss, the court found that the facts Ross pled support theories of liability under Sections 1 and 2 of the Sherman Antitrust Act because they allege an illegal tying of the case law database itself to West Search Tools and the Westlaw Research Platform. In June of 2023, TR purchased a company called Casetext, which was a competitor of Ross's in the legal-powered AI space, who was able to jump ahead over the last couple of years as Ross shut down operations to focus on this litigation, which is a really interesting twist on all of this. Now, as I alluded to earlier when I mentioned OpenAI's ChatGPT software, we will finish up here where we want to talk briefly about the ramifications of all this. With respect to the online legal research you do now, whether it's in free databases or on platforms to which you subscribe, I hope you're already thinking about, for example, how some of the challenges Sara described could impact problems you've encountered or what you've perceived as holes in collections or features that you'd like to see either on free or sometimes even paid legal research platforms. Whether you're comparing the outputs of different courts or different federal agencies or entirely different states and their various courts, agencies, and legislatures, I trust it's clear that the lack of standardization makes it very difficult to create purely technical solutions to gathering, processing, sorting, and displaying in a useful way everything that's being produced, and more importantly, everything that you might be hoping to find when you find yourself needing primary legal materials to answer your research questions. Similarly, with the material I presented on copyright, you can imagine, for instance, the state of play when LexisNexis owned and enforced what it believed to be a valid copyright in the official code of Georgia annotated. What kind of license terms did it dictate to other legal publishers if it agreed to license that content at all? And what would those other publishers do if they couldn't get or couldn't afford that license? You can't be charging lawyers in Atlanta to use your legal research platform and simply say, sorry, we don't have the actual law of the state of Georgia because Lexis has an exclusive deal with the state there. But what I really hope you'll think about after we're done here shortly is the implications on this AI revolution we've all been hearing about, and we're all being told will completely reshape what we do and don't do as lawyers going forward. I know there are plenty of other webinars that will teach you about how AI systems, including legal AI systems, work. And I'm sure some of you know a little something about the large language models they use, or at least aware that these LLMs exist and play a crucial role. So think about how these copyright cases potentially imperil the data sets on which large language models feed, and thus the completeness of the models themselves, as well as the quality of their outputs in a legal services context. It's clear that the various tech companies who pretty much harvested the entire open internet to create these LLMs completely ignored copyright. Will that come back to be the undoing of the whole thing? I also know that everybody has a legal AI product either already out there or in beta or coming soon. Here's the aforementioned case text, and here's what TR was saying about AI before it bought case text. This is the LexisNexis AI product. And lastly, this is VLEX, which now owns Fastcase, which I'd imagine many of you use as a bar association member benefit. And I don't think it requires either tremendous expertise or tremendous imagination to see the implications if the courts say that copyrights and standards incorporated by reference, for example, are valid and sufficient to prevent others from publishing or even making copies of those standards. I also think it's controversial to posit that the advice one can get from, say, an AI-powered expert system for regulatory compliance is going to be much better if it can actually quote you the standard your explosion-proof plug must meet, compared to the advice from a system that avoids copyright issues, but by providing instead a summary of that standard, or tells you to go look up the standard yourself, or helpfully offers you a link to where you can buy NFPA 70 for the low price of $145.50. Now, we talked about fair use and the concept of transformative use. There are some recently filed cases regarding image generating AI that haven't really gotten going yet, but may ultimately decide this very issue of whether feeding copyrighted stuff into generative AI as a matter of law is sufficiently transformative to justify ignoring the valid copyrights into that stuff. And very, very recently, the comedian, actor, and author Sarah Silverman and others filed a pair of class action lawsuits against OpenAI and Meta, seeking to enforce the copyright in their books that have allegedly been fed into LLMs despite their presumptively valid copyright. Now, I earlier posited the hypothetical question is this copyright issue what's going to bring AI down? And the answer to that question is probably not. Given some cases I mentioned earlier, such as the Authors Guild v. Google case about the digitizing of books, and especially the Google v. Oracle case about JavaScript copying, transformative use doesn't seem to be a particular close question, but the Supreme Court did something in May of 2023 when, in a case involving Andy Warhol's work, it reversed a trend that seemed to be expanding fair use that maybe will have us someday looking back at Google v. Oracle as perhaps something of a high watermark. On the slide, you see a screen cap from a SCOTUS blog article. The court held that the picture on the left, which was licensed by Warhol's estate to the Condé Nast Group for a magazine cover and was Warhol's interpretation of a photo of Prince on the right, taken and owned by Lynn Goldsmith, was not fair use of the Goldsmith's photo. In doing so, the court took the concept of transformative use quite literally and said that both the Goldsmith photo of Prince and the Warhol version were both photographs suitable for licensing by the magazine. In other words, the magazine could have accomplished the same commercial purpose by licensing the original photo, so there was nothing transformative about its licensing of the Warhol version. Instead, the dissent focused on the transformative artistic elements of the Warhol work itself, since, after all, that's where the alleged infringement lay, and not the subsequent commercial use of that work in the form of a magazine cover. Still, in light of Authors Guild v. Google and Google v. Oracle, I don't really think at the end of the day that the Warhol decision changes the likely outcome of any of the litigation around AI and copyright that actually exists now or might exist in the near future. And I've spoken with others who are watching all this, and they agree. But it may well change the risk calculus for all involved parties or potential parties, and thus alter their conduct in ways both predictable and not. I wonder, for example, if the advice that Sarah Silverman was getting from her lawyers about suing Meta and OpenAI changed after the Warhol decision came out. Meanwhile, legal uncertainty could slow investment in our adoption of legal AI systems. We'll leave for another day the question of how we feel about that, because that's our time for today. And we're happy now to take any questions that you have.
Wonderful. Thank you, Craig and Sarah, for joining us today. Okay, so it looks like we've already got a couple questions here, but if you do have questions for Craig and Sarah, feel free to submit them through that Q&A button at the control panel at the bottom of your screen. We'll go ahead and dive right in. So our first question is there a difference between the information I can get as a lawyer when using free research sites like Justia or LII rather than paid sites like Westlaw?
I'm going to start here, but I will be brief because my technologist view is limited. My perspective is that from a publishing standpoint, the primary difference should be the incorporation into commercial services of particular collections of original content, like treatises that they have licensed. And as Craig was discussing, this is a bit bigger than it sounds because licensed content inevitably provides training data for artificial intelligence work, and that's unavailable to the free services and proprietary to each commercial service that is licensing content. In practice, the differences tend to be about budget at both the publishers and your own. Regarding publishers' budgets, though, commercial services, and this is not something I'm sure everyone is entirely aware of, but historically they've applied a lot of editorial effort to manually maintaining very rapidly changing primary law collections and gap filling, which is a resource that free services have either used automated techniques to address primarily or haven't been able to address entirely at all. So from our perspective, as a free and open access to law publisher, that on the commercial side, they get to fill gaps with large amounts of money. But I'll stop here because Craig's experience in legal practice is key here. Thanks.
Well, no, Sarah, I think you nailed it. It would just a couple of points, small points. One being that there is an optimism and a temptation to think that technology can close the gap in some of the secondary sources. Legal AI systems or ChatGPT or however you want to think about it are actually pretty good already at summarizing and categorizing like content. So the idea of feeding every case ever into some sort of machine designed specifically to process all that stuff that then spits out something that's kind of like the West key number system, which is of course manually curated by lots of editors with law degrees in Minnesota. And probably other places. That could actually happen. And Sarah, you touched on this briefly in terms of the quality of the training data that's used to build that machine. And if you own those, the best secondary sources, so in California, stuff like the Rudder Guide, stuff like Witkin, right? If you own that and can incorporate that into your training materials, then you have a little bit of advantage. The other part of that, and actually Justia CEO Tim Stanley is the first one I've heard mention this, is the large commercial publishers also have an advantage in terms of they have, proprietary control over all of their data about how users work through their materials. So they can see how users jump from primary law to the secondary sources that they own and back, how they use their key number system in the case of Westlaw, how they use Shepard's or Keysight, I guess it's called in Westlaw. And they can build tools that sort of account for that right from the bat, whereas the rest of us would have to sort of do that iteratively. So yeah, that's really kind of all I have to add to that in terms of nuance. But yeah, just to reemphasize the headline, it's really, I don't think there's anything primary law wise that's not available for free now. If you know your stuff, and if it's not for free, then maybe do like your fast case subscription, which is practically free as a member of the bar in most places. So it's really the secondary stuff, and then how that, as we're talking about a little bit, how that secondary stuff then sort of snowball.
Perfect. Thank you both for that insight. Our next question is, what would you consider to be the biggest improvement the government can make to the process of creating statutes and regulations?
I think on this one, since on the publishing side, it's the technical crew that experiences most of the pain of the current publishing practices. I'd say my biases are pretty clear. I think I made them pretty clear in my presentation. Essentially, my perspective is that if you need to know something to understand your legal obligations, then the government should be publishing that information. But more specifically, I'd headline by saying that the biggest improvement the government could make would be stepping back to proceed on the assumption that the law that it publishes needs to be relied upon and reused, which means not only free publication, but open publication. And that includes using data standards that have been developed for government data and providing a final, official, timely version of the law as it stands at any given point in time, including annotation with external information about whether the law is actually in effect as written. And I guess I'll just use the excuse to reiterate the quote from Kirsten Gullickson at the U.S. House of Representatives, because it's just that good. That government data should be accessible, accurate, complete, described, free, machine readable, permanent, searchable, timely, and usable. Thanks.
Thank you, Sarah. Okay, it looks like our last question that we have time for today is, do you feel mostly optimistic or mostly pessimistic about the direction in the case law on copyright claims by private entities in this context is going?
Yeah, I guess that's for me. Well, optimistic versus pessimistic is a little bit of an odd lens to look at it, because I guess it depends on what you want to do with it, or who your clients are or whatever. But and I've gotten in trouble with this before, but I'm generally kind of pessimistic, because as I noted in my talk, right now there are, for example, 3 cases that are all dealing with a very similar issue about, of course, standards incorporated by reference, and whether those are in the public domain or whether fair use applies, or all the stuff I just talked about. But those are 3 different courts in 3 different jurisdictions that are dealing with different fact patterns, different standards that were developed differently, but have been incorporated into the law differently in ways that may or may not impact the fair use analysis. The same with, can a PRO as a nonprofit do something that Upcodes as a for-profit company can't do under the fair use analysis? I touched on that a little bit. So the idea that where all of this is going to end in 2 years or 3 years or 5 years or 10 years is with a uniform standard that applies everywhere, because all the courts have agreed, kind of regardless of the details, that the analysis comes out a certain way, is far-fetched. And I think most of the practitioners here that have all kinds of specialties can think of several areas in their practice where that's true, and where it would be really helpful to get some congressional action. And here's where my sort of background as somebody that does a lot of patent litigation, or did a lot of patent litigation work, and whose former colleagues and current friends are still a lot of patent litigators who have been just begging for Congress to do something in patent reform, just to clarify the playing field, because the legal landscape created by the federal circuit's kind of all over the place. The same can be said, kind of for copyright. And in fact, the Georgia v. PRO case, where I spent a lot of time, the court did something it's been doing increasingly in the Roberts Court era, which is saying, if you don't like it, your gripe is with Congress. Tell your, write your congressperson and tell them to do something. So you can't be optimistic about that if you've ever practiced in an area of law where congressional clarification would be useful. So sad to say, overall pessimism, but in terms of simply, do I think that these courts are probably going to find at least fair use, if not public domain? Then yeah, I think it's going to kind of work out, but it's going to, as I mentioned briefly, it's going to have kind of all sorts of strange little twists and turns and unintended consequences along the way.
Well, thank you, Craig and Sarah, and thank you all for your questions. That's about all the time we have today, so I'm going to hand things back over to Marina to wrap things up.
Thanks, Nina, and thanks, Craig and Sarah. That was a very interesting and informative presentation. Thanks to all of you for being here today. It was very good to have all of you with us, and we hope you learned something and found that to be a very interesting and informative presentation as well. You heard a lot about free law and access to the law. And so it's just a reminder here at Justia, we are dedicated to making the law free and accessible for all. And to that end, we have tons of free legal resources out there that the general public can access, as well as all of you as practicing attorneys. So if you visit justia.com, that is the gateway to the Justia legal portal, and you can browse all kinds of free information there that you would normally need logins to view and those kinds of things. So that's a quick reference you can have. But one of the things that is probably most helpful for your practice is our Justia daily opinion summaries. And those are something you guys have access to as Connect members. And what we will do is you can choose your jurisdictions or your areas of interest in practice. And we send you breaking alerts of new cases coming down from appellate courts that you've chosen, as well as the highest state Supreme Courts in your jurisdiction. And we'll kind of summarize those cases and deliver them directly to your inbox. So if that's something you're interested in, I encourage you to explore that benefit and definitely take advantage of it. Have a great weekend and a great rest of your day.
Thanks for watching. Please complete the verification as prompted by the on-demand platform. If you need any assistance, you can reach Justia support at support.justia.com. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.